Please be seated. Call now cause number AP-77-081, Gustavo Tijerina Sandoval versus the State of Texas.
Good morning, and may it please the court. My name is Janae Swargula, and along with Jared Tyler, I represent Gustavo Tijerina Sandoval, who is appealing his capital murder conviction and death sentence out of Cameron County. This is an unusual case because we in the state agree that the trial court committed error when it held a portion of jury selection without Mr. Tijerina Sandoval or his counsel. Yes.
Was the attorney present or not? I mean, we've got the docket notation, we got the reporter's record. There's some indication in the discussion about the mistrial that maybe counsel was present. So what's the deal?
We believe the record is clear, excuse me, that counsel was not present, and we believe the record is certainly clear that Mr. Tijerina Sandoval himself was not present. As this court is aware, there were three separate jury panels, three special veneer panels called here. For each of those panels, the court reporter's record says in two separate places at the beginning of those proceedings, and then when the court moved into the qualification proceedings, that counsel and the defendant were not present.
But how can we be sure that that is not a mistake in the reporter's record that needs to be corrected?
I think when there are 6 instances in the reporter's record on 3 separate days that all indicate, or that all state that counsel and Mr. Tijerina Sandoval were not present, that's an accurate representation. And I also just point the court on the last of those 3 panels, at the end of those proceedings, the court says on the record, bring the attorneys in here, which I also think is an indication that they were not present.
Were defense counsel and his client aware that these proceedings were occurring?
For the second 2, yes, they were. For the first one, what counsel puts on the record during the motion for mistrial is that they had gone and tried to attend and participate in those proceedings, and the court prohibited them from doing that. It's not on the record what was said during that discussion because the court had ordered those proceedings to be off the record. So defense counsel had filed a motion to record all proceedings, so there's no reason to believe that they would have known that those proceedings were off the record and that whatever that conversation was about their attempt to participate wasn't on the record. But we do know then from what they put on the record later at the motion for mistrial that they did attempt to go, and I would like to emphasize that that was the very first day of the jury proceedings. That was the first.
So for the,
Actually, let me ask you that. Like, was this a situation where there was a whole qualification, it was a general qualification, and then there were these special panels, and the judge did some more qualifications, excuses, things like that?
No, there were. It was special panels. It was 3 special panels ordered by the court. The first one of 400 jurors, the second 2 of 150 jurors, specifically for this case. And the jurors who arrived had received the questionnaires prior to arriving, so they knew it was for a capital murder case. Mr. Tijerina Sandoval was identified as the defendant in those questionnaires, and so I think there's no question that these were special panels. Special veneer called for this case.
Right, but it's not a situation where there's a massive group of people that were called and there's a qualification process where no one needs to be there except the judge, and then
Right.
there's special veneers. Is the special veneer that were called the place where the qualifications actually took place?
Yes.
Or had there been their pre-qualification before this?
No, as far as I'm aware. So yes, I think this is the same situation as this court's opinion in Jasper, where it was a special veneer called for a particular defendant's case. And what this court said in Jasper is that does constitute a part of that defendant's trial, and that then they have a 6th Amendment right to be present, and as well as a right under Article 3303.
so were the questionnaires given to all 400 people, or just the 150 that are sliced off for this particular case?
Right. What the court said on the record at a pretrial proceeding prior to that first panel is that the court had mailed out the questionnaires. So my reading of the record is that when the summons went out, the questionnaires were mailed out as well.
And you said that, there was, motion for mistrial talked about the first of these special veneers. Did the defense attorney do anything about the second and third ones?
They did not, but presumably they had, made a request to be present. The trial court had denied that request, and so I think further objection would have been futile at that point, because they had already requested to be present. And what defense counsel said is that they were prohibited from doing that.
Was the state present for that? And the defense counsel was not, or was it just the judge?
I believe it was just the judge. What the record says is a defendant and counsel present. It doesn't specify counsel for the state or counsel for the defense.
So let me understand what you're saying. You're saying that the defense asked to be present during excuses, and the judge said you can't be there?
That is my reading of the motion for mistrial transcript, yes.
And, okay, thank you.
How many people were excused?
It's a little bit difficult to piece together from the record, but what the judge says, we know from the juror attendance sheets that there were, for the first panel, that there were 335 people who appeared, and during general voir dire that took place immediately after that, when counsel and Mr. Tijerina Sandoval were present, the judge said that there were 200 people. So we believe from the record that there were, just in that first panel, 135 jurors who were dismissed in his absence.
Can you identify the specific statute and/or constitutional provision that you contend guaranteed the defendant's right in this case to be present during the particular phase of proceedings that we're talking about here, which the general qualification stage?
Sure, Your Honor. So in Jasper versus State.
I know Jasper, but I'm asking about the statutory and constitutional, the specific statutory and constitutional provisions that.
Yes, yes. So the Sixth Amendment right to confrontation.
Against witnesses? Are jurors witnesses?
So what this court has said is that there's a right under the Sixth Amendment to be present at all phases of trial.
Okay.
And that was the constitutional provision that was relied on in Jasper. And I would also just say, and similarly, the United States Supreme Court has said that there's an absolute right to be present at the commencement of trial under the Sixth Amendment.
Right.
Well, counsel, given that, Jasper only assumes that the trial had begun. What's your argument for the fact, or what's your argument that the trial had actually begun during the qualification?
Yeah. My reading of Jasper is that there was some ambiguity in the record about whether it was a special veneer or a general veneer that was called, and so the assumption is that it was a special veneer that was called, and if that was the case,
Right.
that it was a part of the defendant's trial. But I think here, particularly where the jurors had received the questionnaires, they knew the case that they were being called for. And in fact, for the second panel, a few of these proceedings are on the record, and there's one juror that says, I don't feel comfortable serving in this case, but we have no idea.
Is the second panel part of the special venire panel?
Yes, it
And
was.
did the special venire panel get the questionnaire at that time, or did they hold off until the second panel came in?
Yes, there were three. So the second and third venire panel were several weeks after the first, because they had gotten through the first panel and hadn't yet chosen a jury. So then they.
In a lot of counties, you just have a large panel that comes in.
Right.
They're qualified by the judge. You never know where they're going to go. How do we
Right.
know from the record that this group was designated to go exclusively to the capital case?
I think that there are three things that indicate that. One is that the court's order is, the court's three orders for each of the special panels are specifically for a special venire. I think the fact that that the questionnaires went out in advance indicates that they were being called for this panel, for this case. And during the first panel, at least, the judge tells, during the qualification proceeding, says to the entire venire that you're here for a capital murder case. And so I think that clearly
But
And-
beyond that, was there anything discussed about the nature of the case, the punishment, or was it just you're here, fill out the questionnaire, and I'll entertain any excuses why I should let you go?
On the record, no, but that is a part of the problem here is that the trial court ordered these proceedings off the record, so we don't know what was discussed, what potential jurors said during these excusals and qualifications that may have, because they knew about the case that they had been called for. We don't know what was said. As I was mentioning, there is one juror who on the record said, I feel uncomfortable serving in this case. But there's no follow-up on that, so we don't know the reason why. But I think the record, there's plenty in the record to establish that the,
Does the absence of the record in this case constitute a lost or destroyed record, or just wasn't a record that was made?
I believe under this court's precedent, and specifically under Berry versus State, it's just a record that was not made. In Berry versus State, what this court said is that off-the-record proceedings are not considered a part of the record, and therefore can't be sort of supplemented. So, yeah, it is a, despite defense counsel's best efforts to have all of the proceedings recorded, this is an off-the-record proceeding. That's
So your argument isn't that under Rule 34.6, the client is entitled to a new trial because the record is lost?
I think 34.6 is the most analogous provision available, but I don't think that this qualifies as like
Okay.
a lost or destroyed record under sort of the meaning of that rule, in which, the parties were present, can participate in a potential reconstruction. Here, no one was present, and so the parties would be unable to offer sort of any opinion on the completeness or the accuracy of any.
Yeah, like, the rules will allow you to go back and
Right.
and find out they won't let you go create a record. They'll allow you to supplement the record with something that exists, but they won't necessarily let you go back and recreate a record that wasn't made.
And this is not a situation where the court reporter may have taken it down, just didn't transcribe it?
There's no indication of that. The court reporter asked, are these proceedings on the record, and the judge said no.
And you were not, or counsel was not present when that happened for any of the Renars?
There's no indication in the record that they were.
I know that the judge had ordered a year or two previously that all the proceedings be recorded, but I can't remember the name. It seems like we have a case that says that even if there is an order to record proceedings and the judge says, come on up to the bench and don't record this, it's the responsibility of counsel to ask that it be recorded. Is that right?
Yes, I am not familiar with that particular case, but I do know that there are, plenty of instances during trial where the parties will go up to the record and have an off-the-record bench conference that then isn't a part of the appellate record. But here, as I mentioned, the record says at the very beginning of those proceedings that counsel isn't present, so they wouldn't have been there to sort of reinforce or re-urge that motion that those
Well, let me
proceedings.
ask you, I don't remember seeing in your brief any mention of the motion for new trial hearing. Did you brief that?
The motion for new trial?
In point of error 11, 12, and 13, you're saying in the motion for new trial, there was an allegation that counsel wanted to be present and the judge told counsel that he couldn't be. I don't remember seeing that in your brief.
If I said motion for new trial, I misspoke. It was a motion for mistrial.
Maybe you said motion for mistrial.
I believe we included those facts in our brief. Our brief is
It
at.
may not be under 11, 12, and 13.
There was a motion for new trial filed, it just didn't discuss this issue.
Right. I believe that pertained to some evidence related to a chain of custody issue with some evidence. I can check our briefs though and let you know if I believe we reference it in our.
Okay, maybe I just don't remember it. Thank
Yeah,
you.
but I'll check when I.
Did you want to reserve some of your time for?
I did, yes. I reserved 5 minutes for rebuttal. But I believe I have 1 minute left on my
Oh, okay, sure.
opening.
I do have one more question.
Sure.
And this one is about Jasper, or at least about something that's said in Jasper.
Mm-hmm.
And my question goes sort of beyond Jasper, right? And that is, it says in Jasper that the General Assembly portion of the jury selection is not considered part of the trial, and therefore the accused is not entitled to be present. And so I recognize that Jasper seems to suggest something different, and they kind of turn it on Well, here they told the jury that they were there for a capital murder. I'm curious, number one, do you agree that having informed the jury about sort of somewhat the nature of the proceeding that they might be there to be qualified for changed the calculus somehow from the general rule that we acknowledged in our opinion that generally they're not entitled to be present for that pre-qualification stage? What is it? I mean, explain to me, number one, if you believe that it's because they did tell them you're here for a capital murder, or is there some other thing underlying all this that changes the calculus, right? That they're ordinarily not entitled to be there.
Yes, Your Honor. I think it is in large part that they were informed that this was specifically for Mr. Tijerina Sandoval's case, and as I mentioned, there was one juror who brought up not being comfortable about sitting in this case, so I think without a record, there's no guarantee that other information that could have been relevant to Mr. Tijerina Sandoval and his counsel in the strikes how they elected to exercise both their strikes for cause and their peremptory strikes, that they could have learned specific to his case during those proceedings. And I do also just want to say, I know it's an unpublished case, but this court in Calvert did reaffirm that qualification and excusal proceedings, when a special venire is called, does constitute a part of a particular defendant's trial, at which he has both a right under the Sixth Amendment and Article 3303. I think I didn't finish that.
Thanks. I
Answer,
appreciate that. Yeah, really.
To be present, yes.
Okay, one more thing. I did find where you say that in your brief, you say defense counsel objected to the fact that the trial court did not prevent defense counsel to be present. And in response, the trial court told defense counsel that he said you didn't need to be there. So the trial court seems to be disputing that he didn't allow you to be there. Is that right?
The trial court does say you were there, but
No, not that you were there, that you didn't need to be there.
right, and the trial court, right. And I will also just add that there's nothing in that motion for mistrial colloquy that provides any indication that Mr. Tijerina Sandoval himself was present, and the right to be present under 3303 and the Sixth Amendment is a personal right to the defendant.
I understand that.
Yeah.
What I'm pointing out is that you alleged that you were not allowed to be there, and the trial court seems to dispute that allegation and say, I told you you didn't need to be there, not that you couldn't come.
How trial counsel framed it was we were prohibited from coming, so I would agree that there's like a disagreement between
Okay.
counsel
Thank
and the
you.
court about that.
Appreciate
Yes.
it.
All right. Thank you.
May it please the court. My name is Rachel Patton, and I am here on behalf of the Willacy County District Attorney's Office, which is the county that this case arose from. It was tried in Cameron County on a change of venue, though. So in 2018, the appellant was convicted and sentenced to death for the murder of Javier Vega Jr. Direct appeal was had to this court, and in response to the appellant's brief, the state filed a brief in which it conceded that, on the record as it stands, the state is currently unable to meet its burden on 3 issues related to jury selection.
So counsel, are you going to stick with that concession or not?
Yes, Your Honor.
Okay.
We did note that in light of the significance of this case and the type of case that it is and the amount of resources that are involved in it, that we believe that in the interest of justice, that this court would be authorized to remand the case to determine if there are any additional factual developments that could be determined to assist the state in being able to reach its burden.
So counsel, you're asking, or you're arguing that we should be able to send this back for an evidentiary hearing. What authority and how do we do that? I mean, wouldn't we sort of be going on voyaging on seas of unknown thought? I don't think I can think of a single case where we have remanded like this in a direct appeal as opposed to, say, a writ or something. So what's our authority to do that?
Yes, Your Honor, I would agree that I have also been unable to find a case that is analogous to this. This is unfortunately a very unusual situation, and that would be why we are presenting the court with 2 options, that we believe that on the record as it stands that we cannot meet our burden, but because of the very unusual situation, we believe that it would be appropriate under this court's authority under Rules of Appellate Procedure 78.2 and 78.3 to remand this issue in the interest of justice.
Do you have any position regarding the question Judge Keller asked, and that is, was the defense and his lawyer prohibited from being in the proceedings, or just told they did not need to be there? Or do we know?
Your Honor, the record is unclear on that. The mention of the motion for mistrial, we did quote the entirety of that in our brief, and I believe we've already heard basically a recitation of what was stated, and the court responded that it was just the pre-qualifications, and I told you didn't need to be there. In fact, you were there, though. So that seems to leave some question as to whether or not they were there the entire time, because counsel indicates previously in that colloquy that he had attempted to come in there, but that he couldn't get in there. So there seems to be some ambiguity as to whether or not he was there the entire time, or whether or not he was allowed in. And we believe that's one of the instances that a remand could clear up.
Was the state present?
Again, Your Honor, there is no indication that the state was, but there is no indication that the state was not. The court reporter's record simply states at the very beginning that the defendant, the court interpreter, and defense counsel were not present. It makes no mention of the state.
At the very least, we could regard that reporter's record notation as ambiguous or in error and remand it to determine whether or not that is accurate. And if we determine that counsel was actually there, a lot of this issue goes away.
That is correct, Your Honor. That is the state's position.
But both parties were aware that the judge was going to hear excuses at the time that he did. Is that correct?
That is my understanding. I don't believe it's explicitly stated in the record, but as this was conducted immediately prior to the general voir dire, which everyone was present for, one would presume that they were aware that this was taking place, particularly in light of the fact that the defense counsel indicates that he attempted to get in, so he at least knew that it was taking place.
I understand the court reporter situation, but is there anything on the docket sheet or anything in the actual clerk's record that would indicate who's there when?
Yes, Your Honor, the docket sheet, and this is again part of the ambiguity that we believe a remand could clear up, but the docket sheet for all 3 days states that, and it states that the state, the defense, by all these individuals by name, appeared for jury qualifications. The court heard jury excuses and possible exemptions and disqualifications. Court proceeded with general voir dire. That is how the docket sheet reads. So we believe that that creates significant ambiguity in comparison with the reporter's record, such that a remand could clear this up and possibly help resolve these issues.
I have a question. It has to do with our opinion in Jasper.
Yes.
In Jasper, we said that under the Sixth Amendment, the court said that under the Sixth Amendment and Article 1, Section 10 of the Bill of Rights in the Texas Constitution, and here's a quote, "The scope of the right of confrontation is the absolute requirement that the defendant basically be present in the proceedings." Confrontation is a right dealing with the relationship of the defendant to the witnesses in the case, is my understanding anyway. And I'm wondering whether you have any opinion about whether or not the court was right to say what it said in Jasper.
Yes, Your Honor. Based upon our reading of the totality of the statutes as well as other case law, we believe that that would be an accurate statement, that in the event that there was a special veneer order issued, the defendant has a right to be present because at that point the trial has begun. Now, as has been noted, if this was a non-capital case, or even if this were a capital case where no special veneer order had been made, and they conducted qualifications and a general jury room, then no, the defendant would not have a right to be present. So this particular situation hinges on a lot of details that kind of constellate together to create where we're at.
So has the court essentially then almost created a special rule for capital cases because their voir dires are conducted differently under, with a unique set of circumstances where trial judges typically call lots more potential veneer into the jury room to qualify beforehand?
Yes, Your Honor, that is our understanding of the precedent in the case law, that this is a special exemption kind of carved out for capital cases.
And am I right to conclude that you have come to the conclusion that the court's decision was correct in Jasper, completely outside of what the court happened to have said in Jasper?
That is correct, Your Honor.
Counsel, was the trial, or had the trial begun or not, and why or why not?
Your Honor, we believe the trial had begun at that point because, first of all, the Code of Criminal Procedure 3303 gives the defendant a right to be present, and that right is unwaivable at that particular point before the jury is selected. Additionally, the Code of Criminal Procedure 34.01 provides for a special veneer to be created in capital cases only, and combined with this court's opinion in Jasper, we believe that those three issues together create the situation where trial has begun if the special veneer has appeared.
The penumbra of the statutes is what you're saying? Emanates from the penumbra of the statute?
No, Your Honor, not the number of the statutes, the combination of the statements within the statutes.
Gotcha.
Is your position at that stage of the proceedings? Because typically, a judge would just hear the jurors why they can't be there because of age or kids or anything like that. Does either party have the right to ask questions of those being excused at that point? Or do they just have a right to be there?
I believe that under certain circumstances, they may have a right to ask questions depending upon whether or not it's an absolute disqualification or a mere disqualification in that type of situation. So I think they would have a right to be there, and at least they would have a right to object on the record, so therefore to preserve any issues for appeal.
Do you, in Jasper, we said we're going to assume for the purposes of argument that the defendant had a right to be there, and then we found that any right that he had any error was harmless. Do you see that there's a difference between assuming error for the purpose of argument and holding? We didn't hold in Jasper that the defendant has a right to be there, did we?
Yes, Your Honor. We recognize that that was the case in that particular set of facts. However, again, when we looked at the facts in this case and we evaluated everything that we could come up with, we believed that in our duty to provide candor to this court and our duty to seek justice, that our understanding of the case law was such that we had to point out to this court that we didn't think that we could meet our burden. Now, we're not necessarily conceding that once we get enough evidence from a remand that we could not meet our burden, but at this point on this record, we don't believe we can. We would welcome the court to clarify if we are incorrect.
Is there a burden to show harm or not harm or rebut harm, or is harm just something that courts look at? I mean, you keep saying that, and it makes me wonder, I don't believe that it makes me wonder about your argument, because I don't believe there's a burden to show or disprove harm. It's just that something we look at the entire record to determine whether the error has resulted in harm.
It was our understanding that the state's burden maintains through the appellate process, and that in the event that we are unable to demonstrate or point out in the record that there are certain facts that indicate that the jury was appropriately selected or did not contribute to the conviction or punishment, that if we could not demonstrate that on the record, then therefore we could not meet our burden of proving beyond a reasonable doubt.
Right. So the constitutional error harm standard sort of says, sort of leans on the side that it's harmful unless you can show that it didn't contribute, or unless someone can show, unless the record shows that it didn't contribute. But if this is statutory error, isn't it the opposite, which is it didn't contribute unless there can be a showing that this was something that was significant? We say it didn't really affect substantial rights.
That is correct, Your Honor. If we were looking at this solely as a statutory error, it would be a different analysis, but the court was clear in Jasper, and I don't believe this was an assumption that if this error were in fact to have occurred, it was both statutory and constitutional.
All right.
Are you familiar with either Krutzinger versus State or Black versus State?
I'm sorry, Your Honor. What was the-
Krutzinger or Black? I can't remember if you cited him. I don't believe you cited him. Either party cited him. In Krutzinger, which was capital case, well, let me go back to, in Black, we held that the trial court did not abuse its discretion to sua sponte excuse a prospective juror because of her hearing problem, even though the excusal was off the record and out of the presence of the attorneys and the appellant. Now, we know what happened because it was on, all that was on the record, but that would seem to indicate that a judge has authority to excuse a juror for a reason like hearing difficulties, even if the parties are not present, even in a capital case. Are you familiar with Black or Crutzinger?
Your Honor, I'm
Crutzinger
not,
cites Black.
sorry, Your Honor. I am not familiar specifically with Black. We did cite the Crutzinger in our brief
Okay.
to point out that the trial court does have broad discretion to dismiss individuals for, whatever, purpose, as long as it's not economic under one of the code sections. And the CCP, I believe it is the CCP 3503, which indicates that as long as it's not economic, the court, as long as they find there is good cause. However, in the Black case, as you just mentioned, I believe you said there was a hearing problem. That would be good cause and the court would have discretion to do so. However, and again, this is kind of the combination of problems we've got in this case. We don't have a record, so we can't point to anything that can explain, this is why the judge did it and they had discretion to do so. We just don't know, Your Honor.
Well, is there a burden on either of the parties to request a record when the judge says this is not going to be on the record?
Yes, Your Honor. However, the defendant, at this point, we cannot prove was present to request that record or to object that there was not one.
So, but the defendant was aware that the judge, both parties were presumably aware that the judge was going to begin voir dire with excusals. And there's a dispute about whether they were prevented from coming into the courtroom or whether the judge said you don't need to be there and not told them they couldn't be there. And I guess all that matters, but yeah.
And there was
Thank you.
also a motion to have everything recorded. I'm a little concerned with the concept of remanding for evidentiary purposes because I'm kind of wondering why the state didn't already, research whatever they could for the purpose of this direct appeal.
Your Honor, that is a good question, and the answer to that is that we did not know what issues were going to be raised at the time that this record was filed and the time when it would have been, necessary to supplement this record. Therefore, considering the volume of the case, we had no idea whether or not this was going to be an issue at all at that point. If the court has no further questions?
One more question.
Oh, yes, sir.
Yeah. In your brief, there's a quote from Rudy Ayer where it says, it's a discussion of the harm analysis, I believe. An appellant is harmed by constitutional error unless after reviewing the record, the reviewing court determines beyond a reasonable doubt that the error did not contribute to the conviction or punishment. So is there anything showing in the record that you know of that it did, that the defendant's presence did contribute to the conviction or punishment?
Your Honor, this was not specifically mentioned in our brief. However, there is a specific juror that on the second jury panel that was recorded that is at least questionable whether or not that juror was properly dismissed. There was a juror who stated...
This is the second panel?
Second panel, yes, Your Honor.
Thank you.
Does the court have any other questions?
Thank you, counsel.
Thank you, Your Honor.
I have just a few points I would like to make in rebuttal. One thing I wanted to note is to the extent that the court believes there's some dispute about whether counsel was present, I just wanted to highlight that what this court and the Supreme Court have said is that the right to be present is personal to the defendant and can't be waived absent some sort of action on his part. And there's nothing in the record here that indicates Mr. Tijerina Sandoval was voluntarily absent from these proceedings. And in fact, because he was incarcerated, the judge is the person who had the authority to bring him to court. So I just wanted to highlight that, Judge Erie, on your questions about the confrontation clause, and I apologize, this is not a case that's in our briefs, but I wanted, and we'd be happy to file supplemental authority, but the Supreme Court in 2004 also said that the Sixth Amendment provides a right to be present at all stages of the trial where his absence might frustrate the fairness of the proceeding. And that's Tennessee versus Lane. It's 541 U.S. 509. And then I believe, Judge Newell, it was your question on statutory harm. The other part of the statutory harm standard is whether the harm had a substantial or injurious effect, or whether the court is left in grave doubt about whether that. And I think the absence of the record here, and particularly if we're talking about the statute, the fact that this is a mandatory and unwaivable statute through jury selection would bear on that harm analysis. And then the last point I would just like to make is this is about more than whether there was reversible error that potentially occurred during these proceedings, but it's about the right to be present and the right to defend. And so it's also about information that could have been learned by Mr. Tijerina Sandoval and his counsel about potential jurors, potentially specific to his case, that would have informed how they...
What do you make of the docket sheet?
I think the docket sheet, the reading of it that sort of makes the most sense with being read in conjunction with the court reporter is that it's recording the presence of counsel and Mr. Tijerina Sandoval on that day, and they were present for the general voir dire proceedings that took place immediately after these qualification proceedings. So that's how I read
But the
it.
court reporter doesn't make the docket sheet.
Not to my knowledge. I believe that it's the clerk. I don't know that for sure.
And is there anything on the jacket that indicates who's present?
I don't.
The jacket of the clerk's record?
Not that I'm aware of.
May I ask you, how do you respond to the state's suggestion that we remand and further develop the record?
I believe that remand is unnecessary here because both, I think, the court reporter's record is clear about both Mr. Tijerina Sandoval's absence and his counsel's absence. And even if the court believes there's some question about counsel's presence or absence, that there's no indication that he himself was present on the reporter's record.
He was present for later part of voir dire, correct?
Yes.
Is there an allegation in the motion for mistrial that...
Judge Keller, I can't hear you. I'm
is there
sorry.
an allegation in the motion for mistrial that he was present and ready to come into the courtroom for the earlier part of voir dire?
The record is silent on that.
Okay.
How about in the motion for new trial? Was it brought up?
I don't believe so, Your Honor.
And one more question, too.
Sure.
Is there any question or doubt that the defendant and his counsel were present for all stages of the formal voir dire proceeding once the jurors were qualified?
No, there's no allegation that they were not present for the general voir dire that took place after the qualifications or the individual voir dire.
Okay. And did that general qualification occur in the actual courtroom where the trial occurred? Or was it in some sort of a central jury room like I've seen in some of the bigger counties?
That I don't know the answer to,
Okay.
Your Honor.
How... Counsel and Mr. Sandoval were present for the more formal part of voir dire. How were they notified? Is there any indication about how they were notified to appear?
There's no indication about how they were notified.
Did you raise an issue regarding a separate issue regarding the judge's refusal to allow counsel and the defendant to be present for the first part of voir dire?
I believe that those are the issues.
Oh, wait a minute, that's not what I meant to say. Did you raise a separate point of error about the failure to record the proceedings?
We did, Your Honor.
Okay.
And I would point out, because they had filed the motion to record all proceedings, and they don't appear to have been present based on the court reporter's notation that they were not present when the court ordered those proceedings off the record, that there would be any way for them to know that those proceedings weren't being recorded.
Are you familiar with Kretzinger and Black?
I am.
Okay. am I,
I apologize, I'm familiar with Kretzinger, I don't know if I'm familiar
well,
with.
Kretzinger cites to Black, and Black says, well, I don't know where it is. Black says that the judge was allowed to excuse prospective juror without the presence of the parties for a hearing problem in a capital case, as long, when those proceedings were on the record. Wouldn't that seem to indicate that if these proceedings had been on the record, the judge would have the right to have excused whoever was ineligible for jury service?
I think in the absence of the record and in the sheer number of jurors that were dismissed here, it's just really hard to say because we don't know the basis for which jurors were found disqualified or excused.
Right, that's my point, that if it had been on the record, you would have known. And in that case, Kretzinger, it seems like Kretzinger and Black would have said what the judge did was okay, as long as the excusals were proper.
If the excusals were proper, I think that's possible, although I think it would also depend on if there would be arguments about harm to be made for jurors who weren't excused, but who maybe did say something about this specific case of which counsel and Mr. Tijerina Sandoval would be unaware because they weren't present. So without a record, I think it is difficult to make
So
that assessment.
how do we decide what happened, whether the judge refused to allow you into the courtroom, or he just said you don't need to be there and then you didn't come? How do we know that?
I think, I think that is a dispute in the record. But again, I would just say this right is personal to Mr. Tijerina Sandoval, and there is nothing on the record to indicate that he was brought for the proceeding.
But that would be the defense's burden to bring him, right?
This court has said actually that the right to confrontation, that is up to the court to implement, and it's not necessarily up to counsel to implement. That was in the context of a case where the defendant didn't speak English, counsel didn't request an interpreter, and this court found it to be a Marin Category 2 right, and something that it was up to the court to implement, to make sure that the defendant had the interpreter needed to be present. So I believe the burden is on the court.
Is that how it usually, I don't know, is that how it usually happens? The court orders the defendant to appear or to be brought to the courtroom at a specific time?
I believe so. I can't say I know for sure in every county or how it generally works, but the court is the entity with the authority to do that.
And he doesn't need to be asked?
No.
Okay.
And is there any information from the jail as to whether they had transported him or anything like that?
Not in the record that I'm aware of.
Okay.
If the court has no further questions, we would ask this court to reverse and remand for a new trial.
Thank you, counsel.
Thank you.
Thank you both for appearing.